I'm Catherine Frankie. I'm from the law school across the University of Columbia, and I'm going to moderate today's panel, and I want to welcome all of you to this terrific gathering on military justice, Palestinians in Israeli courts. This is one of the several panels or events that have been planned around Palestine and law that the Center for Palestinian Studies has coordinated over a several-year period, and there will be more to come, so keep an eye on the website and otherwise for the next iteration of this set of hard conversations about the law and about Palestine. The Center for Palestinian Studies is in its third fabulous year, and this is one of the many wonderful things it does. And if you're not on their mailing list, please do so somehow.
Palestine at Columbia.edu.
It's a good address. Palestine at Columbia.
Is somebody's phone? It's your phone.
You're wondering we should start some electronic things around the room.
If you see something, say something. We've all learned our roles well. So anyway, so we have a jam-packed agenda for today, so I don't want to waste too much time with anything that I have to say, other than that since the War of '67, Palestine, the West Bank and Gaza have been under a form of military occupation that has included military legal occupation. And some have thought that there's not enough law on the scene in the Israel-Palestine context. Many of us would say there is too much law on the scene. This panel is here, so these experts are here to talk to us and to engage with one another about what it means to have military courts and military law be the means of legal occupation and administration of the precarity, if you will, of Palestinian lives in the West Bank and in Gaza. What is the gap between law and justice? In this context, what are the ways in which questions of justice get turned into and work when they are articulated as questions of law? Is law, and particularly in a military context, something that will necessarily deny just and right outcomes under conditions of occupation? Each of the panelists know much more about this than I do, and we're really delighted to have them here to talk to us. Lisa Hajjar is somewhere on the computer. She will be with us electronically. She's an associate professor of sociology at the University of California, Santa Barbara. She's currently visiting professor at the American University in Beirut. And is she here with us from Beirut now? No? Okay, wherever she is. She's an author of Courting Conflict, the Israeli Military Court System in the West Bank and Gaza, and Torture, Sociology of Violence and Human Rights. She served as an advisor on the film The Law in These Parts, which we'll see an excerpt from later in the discussion today. But if you haven't seen the whole film, I really encourage you to do so. It's wonderful and horrible. Next, we'll have talking to us Hedi Viterbo. He's a visiting scholar at Harvard Law School, and he recently completed his PhD at the London School of Economics. The dissertation was entitled The Legal Construction of Childhood in the Israeli-Palestinian Conflict. As he describes it, a central concern of his doctoral research is the way in which the Israeli military legal system treats children and conceptualizes childhood in Palestine. Thirdly, we'll have Yael Berda, who's an Israeli human rights lawyer and a doctoral candidate in the Department of Sociology at Princeton. Her first book, The Bureaucracy of the Occupation in the West Bank, The Permit Regime, 2000 to 2006, was published just last July, and she has litigated cases in the military, administrative, and Supreme Courts of Israel. So if anybody knows about multiple overlapping pluralistic legal systems, it is Yael. And then we're going to see a clip from the film, from The Law in These Parts, and then the fabulous Daryl Lee will provide some commentary on both the film and the presentations that have preceded it. He is a postdoctoral research scholar at the Columbia University Committee on Global Thought. He completed his PhD in anthropology and Middle Eastern studies at Harvard, while also getting a JD at Yale and being in the circus and doing about 100 other things. He just did the JD and the PhD at the same time. It's amazing that a person could do both those things at once, and he did. He's worked in Israel-Palestine, mostly in Gaza, for Human Rights Watch, the Palestinian Center for Human Rights at B'Tselem. So welcome all of our panelists, and welcome all of you. And why don't we get started with Lisa?
Hello, Colombia. Greetings from Beirut. I want to express my gratitude for being able to participate in this conference on the Israeli military court system, and I thank the organizers and the Center for Palestine Studies. I'm going to be presenting, I'm assuming first, so I'm going to provide a bit of history and context of the military court system, and then Hedi, my fellow panelist, will talk about the system more recently, and Yael will talk about it in the contemporary context. So one of the things I would perhaps begin with about the Israeli military court system is its absolute centrality for understanding the Israeli-Palestinian conflict. Perhaps slightly less so since the Second Intifada, and I'll conclude with that. But in some ways, to think about the Israeli military court system in the context of the conflict, for me at least, when I was doing my work on this, I realized it brought to light something that was important, which is that really understanding this conflict, it's important to see it as a struggle over rights, and not simply as a struggle of two people, one land. And that becomes very clear when thinking about the military courts. And by struggles over rights, I mean struggles over sovereignty, existing Israeli sovereignty, and then de facto sovereignty in the occupied territories, Palestinian aspirations for sovereignty, the various populations' aspirations for national self-determination in this context, and human rights. And so if we think about these issues, all of which, I mean, rights are always matters of law. And so the multiple laws that play out to shape the Israeli-Palestinian conflict is really functions as a nexus of local, national, and international laws. And these laws really play out, perhaps in their most explicit way, in the context of the court system, which was established 3 days into the 1967 war. So the military courts themselves are both sites of the conflict, where the conflict plays out, and in a sense are part of the conflict. The history of the courts is a history of the conflict itself. In terms of how the court system works at a very basic level, I mean, the military courts are military, and so the judges are always, and the prosecutors and the translators are always Israeli soldiers. The judges overwhelmingly Jewish Israeli soldiers, the prosecutors most usually Jewish Israeli, the translators have been Druze citizens of the state. And then the defense lawyers have included both Palestinian residents from the West Bank and Gaza, and there's a whole history to lawyering in the military courts, as well as citizens of Israel, both Palestinian citizens and Jewish citizens. And so in some ways, when I was sort of going into the military courts and doing work there, you see that the way in which the court functions, it functions through relationships among these various groups of people performing their distinctive roles. And in that sense, analytically, I also gleaned something that was important to understand in the sense of thinking both about the courts and about the larger context within which they're located. I found that a kind of Foucauldian analysis of government was crucial to this kind of understanding. And specifically government as relational, and it's about the institutional processes and practices of rule. But important to that, and why I found this important analytically, is that people participate in relations of rule, albeit in highly unequal ways. But that was something one can really appreciate about the military courts, is that everybody is there, and obviously virtually no one is there by their own choice, including judges and prosecutors. But the way in which the courts work and the way in which they interact with each other simply can't be understood through the lens of a national dichotomy or other factors. Now, the way in which the Israeli military court system has been absolutely central to the maintenance of Israel's occupation of the West Bank and Gaza is that it's central to Israeli control strategies. I mean, the court system was actually formulated and envisioned back in the mid-1960s, before the war. And it was, as I said, instituted sort of the plan for it was instituted 3 days into the 6-day war, and it was up and running immediately thereafter. From 67, probably until the mid-1990s, when we're getting into the Oslo period, the way in which Israel controlled the West Bank and Gaza, and again, to which the military courts are central, was through what we call a law enforcement model. Essentially meaning the preference for, to some extent, non-lethal use of force and rule-based, law-based, measures of control, including permits, curfews, and so on. But there was the power that the Israeli military had as the de facto sovereign in the West Bank and Gaza included the power to make laws, to alter laws, and so on. And so the law enforcement model may have been and was deeply, unjust, etc. But one can think about it as nevertheless, quintessentially legal. And so the laws applicable in the West Bank and Gaza that get enforced through or manage the Israeli military court system include the British emergency regulations dating back to the Mandate period. Just something to say about that particular body of laws. Those laws were promulgated before World War II, and many aspects of them become illegal in the post-World War II era with transformations in international law. The Israeli government, however, preserved these laws, but kept them, referred to them as the British emergency laws in order to, put the onus on Britain for having promulgated them in the first place. But the much more significant body of laws are those military orders that were promulgated, 1,000 for the West Bank and probably several thousand for Gaza. And these military orders that basically describe what is and isn't legal, what is and isn't permissible, included prohibitions or illegalities that would be obvious, use of force, sabotage, and so on, but also outlawed virtually anything having to do with expressions of Palestinian nationalism, including things such as wearing Palestinian national colors or displaying a Palestinian flag. And the third body of law that's applicable is international humanitarian law, the laws of war. And Israel took a very shall we say, original position on the putative inapplicability of the Fourth Geneva Convention. Now, the law enforcement model, in addition to lawmaking, basically functions through various practices and processes. The main ones, of course, are arrest, interrogation, prosecution, and imprisonment. And so just to illuminate those phenomena, which are both the way in which the military court system works, and again, to reiterate that the working of the military court system was perhaps the most organized manner, or institutionalized manner in which Israel maintained control of those Palestinians. In terms of arrest, any soldier had the power to arrest any Palestinian for any reason. In a sense, there was nothing that would approximate the kind of, necessary, suspicion that would operate under a not so problematic legal system. Once someone was arrested, they would immediately be taken to interrogation center. Typically, people who were arrested were then oftentimes sorted. Those people who were deemed to be perhaps having, violated, basic or small level crimes by Israeli standards would then be turned over to Israeli military interrogators. And those who were suspected of being perhaps knowledgeable about or involved in more important, as from an Israeli counterterrorism perspective, important activities would be turned over to the General Security Service or the Shin Bet. But once people were in interrogation, they could be held incommunicado for protracted periods of time. And I'll come back to that in a moment. But the main purposes for interrogation was twofold. One to elicit intelligence about, sort of what was going on in Palestinian communities throughout Gaza and the West Bank. And indeed, in this sense, we can see the significance of the Israeli military court system as a means of intelligence gathering, because of the fact that, a military occupation does not lend itself to the kind of governing knowledge that a regular state that represents its population would have. The other main purpose is, of course, eliciting confessions. And when there are confessions, when people have confessed, those confessions are then used as the basis for the prosecution of themselves. The prosecutors would then prepare charge sheets, and anyone else who may have been named in the confession would also then be arrested and going through the same routine. And in the military courts themselves, the very significance of confessions, coming out of the arrest, interrogation, detention process, the significance of confessions is that in the military court system, they have a very heavy evidentiary weight. It's almost impossible to challenge, effectively challenge a confession, even if it has been obtained through coercion. And in that sense, so once people have confessed, if they have confessed, or if someone has confessed against them, it's almost inevitable that they will actually be convicted and then imprisoned. And so this whole labyrinth of practices ultimately helps explain, again, pulling back out sort of the military court system in a broader sense, how we can look at Israel's management of the Palestinians in the territories as a form of carceralism. And in that sense, we can see this, in the sense that Palestinians, both individually and collectively, are regarded and treated, through the factors I just mentioned, as suspect and punishable. And as a result of those practices I just described, can be imprisoned in extremely large numbers. And then even beyond the actual prisons themselves is the kind of carceralism that extends outward to all of Palestinian society, in terms of, especially in the sense that, people, so many, particularly men and boys, pass through the court systems, that everyone is caught up in this system. Now, everyone who's involved in the military court system, including judges and prosecutors, regards it as problematic, and it is. It's a problematic system. For one thing, most obviously, it's a result of the conflict, and the conflict is a problem, and it's a manifestation of the occupation, and the occupation is a problem. But it also is a manifestation of, or the problematic aspects are the very blurry and confounding, overlapping aspects, military and legal aspects of control. So among the factors that make the military court system problematic is the very, contentiousness and disputes over the legality of the laws that are enforced through the military courts. I had mentioned sort of the problem of the British emergency laws and Israeli military orders and so on. But those disputes, and actually disputing over the laws has been part of the history of the military courts. Another incredibly problematic aspect is the use of soldiers in a policing capacity. I mean, in the sense of soldiers being expected to provide or gather evidence, which of course they don't do, or can't do in a sense. And part of that was why the importance of confessions is so great, because soldiers simply cannot or will not be able to function the way police do in a society that is not in conflict. The fact that Palestinians are held incommunicado for protracted periods of time is also deeply problematic. I mean, in a sense, typically Palestinians, except for those from East Jerusalem, could be held for up to 18 days without any option to see a lawyer. And so anything that happens in that period of incommunicado detention, including a confession, is something that then comes out of interrogation and becomes a fact and a factor in the disposition of the case. The relationships between lawyers and clients, I mean, not only the difficulties defense lawyers have in accessing their clients, but the way in which politics, Israeli politics, Palestinian politics over the decades has had real ideological and political turmoils has also deeply affected the motivations of lawyers, the attitudes of people from perhaps different factions and so on in regard to, what they want their lawyers to do or how they hope their cases will be handled and so on. Other deeply problematic aspects of the military courts are the availability of secret evidence that neither defendants nor their defense lawyers can have, and charges can be based on secret evidence, the evidentiary weight of confessions, and not least the partiality as contrasted to the impartiality of judges. I mean, this is not across the board a fact. I mean, every judge is not sort of biased per se against Palestinians, at least not in the way in which one would say that all judges would rule exactly the same way. There are ideological and political differences among judges, and certainly judges regard their role as the arbiters in this adversarial process between prosecutors and defense lawyers somewhat differently. But judges, prosecutors, and translators are all members of the same military unit. And so therefore, there is certainly an element of bias built into the system. And that brings us to the point about just the prevailing ideology of crime and danger that is, not absolutely uniform, but certainly there are hegemonic views within Israel about the dangerousness and the suspiciousness of Palestinians. And this is something that manifests among judges. And then, something that is not atypical of criminal courts, but is particularly significant in terms of the Israeli military courts, is plea bargaining. Most criminal courts, in fact, resolve cases as a result of plea bargaining. But in this court system, because of the use of coercive interrogation tactics, and because of the weight of confessions, and because of the protracted period of incommunicado detention, plea bargaining is almost the only way in which Palestinians can resolve cases in any way that would be, in the constricted options available to them, somewhat better than the alternatives. Now, one of the things I wanted to just stress is the significance of torture and the role of torture in this larger process of carceralism and government and so on. And I had mentioned before that the functions of interrogation are to gather intelligence and to elicit confessions. Since at least 1970, Palestinians who had been caught up in the military, arrested and caught in the military courts, alleged that they were coercively treated or tortured and abused. And from 1971 until the late 70s, or at least till the late 80s, those kinds of allegations were staunchly denied by Israeli officials and those who would speak in the name of the Israeli state, simply as lies of enemies of the state. And so what you had was, and this is one of the things about interrogation and torture, is that in some sense, especially back in the 70s, before the development of human rights, the only people who really know what's going on in interrogation are detainees and their interrogators. And so in that sense, due to perhaps the larger way in which Palestinian, resistance to occupation and the Israeli-Palestinian conflict was treated on an international level, unlike the way, for example, Amnesty International treated allegations of torture coming out of South Africa during apartheid, there was much more skepticism towards Palestinian allegations of Israeli torture. However, in 1987, for reasons totally unconnected to the interrogation and torture of Palestinians, Israel established a commission of inquiry to look into the activities of the General Security Services. And this commission was called the Landau Commission because its head was the retired Assistant Chief High Court Justice Moshe Landau. And what the Landau Commission found was contrary to all of the denials. The General Security Services had in fact been using coercive interrogations tactics on Palestinians and interrogation since at least 1970. And that the GSS agents had lied to military judges when those confessions were, in the rare occasions that they were, challenged through what was called a zuta. But the Landau Commission, which basically adopted the General Security Service's own perspective and paradigm on Palestinians, namely that they are collectively suspicious, either actively engaged in or passively sympathetic to terrorism. The Landau Commission argued in some, legal rationales for the legitimacy of what it referred to as moderate physical pressure as a necessary means of combating hostile terrorist activity. And the Israeli government endorsed the recommendations of the Landau Commission, and essentially in 1987, in November of 1987, and thus Israel became the first state in the world to publicly legalize torture. And this happened right at the start of the first Intifada. And so what you get is now, in a sense, a legal veneer over coercive and abusive interrogation practices at a time when arrest, interrogation, prosecution, and imprisonment spiked massively. And indeed, during the first Intifada, Israel had the highest per capita imprisonment rate in the world. Well, the fact that Israel had legalized torture, elicited a response, and again, this comes out of the military courts, by Palestinian and Israeli, primarily lawyers, but human rights organizations. And I might just mention that the first human rights organization established in Israel or the occupied territories was established in the West Bank by military court lawyers in 1979. And it was, in a sense, their work on the conflict and their experiences with the law that inspired them to look to international law as a way to judge what was happening on the ground and to reframe, and forge a legal critique or a counter-hegemonic critique against Israel's arguments that everything it did were legal. And so by the 1980s, and with the start of the Second Intifada, there were by then a number of human rights organizations, and they waged a concerted campaign challenging not only the actual practices of torturous interrogation methods on detainees, but also the whole policy legalizing moderate physical pressure. And that particular, campaign on, through the decade, basically culminated in something of a victory when in 1999, the High Court of Justice issued its decision in that case, saying that routine use of moderate physical pressure, what we in America might refer to as the stress and duress tactics, was not acceptable, although the High Court didn't call it torture and did leave open the option for the use of such tactics under the so-called ticking bomb scenario. The last point where I'll conclude is that, what we see happening, and this was, characterized Israel's occupation of the West Bank and Gaza from 1967 into the mid-1990s. At that point, as a result of changing political situation on the ground, the Oslo Accords, Israeli military redeployment from Palestinian population centers, the establishment of a non-sovereign PA, and then also we might add the already existing secret and at that point denied policy of Israeli targeted killing, and then Palestinian suicide bombing, which began in 1993, I believe. We start seeing Israel beginning to lay the ground for what we would term a war model. And indeed, now Israel's relationship, certainly to Gaza, but as well to Palestinian areas in the West Bank, has, sort of where a war model has come into play, not totally supplanting the law enforcement model, because people still are arrested, the laws are still used to manage and control Palestinians, etc. But this war model, which begins in the mid-1990s and significantly intensifies during the Second Intifada, basically is part of the larger discourse in which Israel has claimed that somehow at least Palestinian areas of the West Bank and Gaza are no longer occupied. They're not sovereign, but they're no longer occupied. Of course, Gaza and the West Bank are, in fact, actually occupied. But in this war model, which is different than the law enforcement model, it's, you know, a sort of willingness to use lethal force and a justification for the use of lethal force, as well as statements that Israel is no longer directly occupying, i.e. administering Palestinian areas, and therefore no longer has any state responsibility for civilians. And to the extent that this war model is used on and in the West Bank and Gaza, and certainly takes a high toll of civilians in the discourse of war, civilian casualties are referred to as collateral damage. Second Intifada was really characterized even before the 9/11 attacks as, you know, Israel's war on terror. And in the framing of this war model was the perception that Palestinians have no legal right to fight under any circumstances. And so I believe my time is up, but hopefully this perspective will offer you something for the conference, and simply again to stress the centrality and the importance of the Israeli military court system to understanding the conflict, to understanding relations of all sorts in Israel-Palestine. And if the internet gods of Beirut smile on me, I'll be with you via Skype for the conference. Thank you.
Okay, so before I start, I should really commend the Center for Palestine Studies for organizing this event. I think Lisa emphasized the importance of the military legal system, but the thing is that unfortunately this legal system hasn't received the attention that it deserves. So hopefully this event will help invigorate public debate about it. And Lisa really provided a very useful kind of broad overview of the military legal system. And what I will do is focus on recent developments. And I'm going to do this through the prism of children and childhood. More specifically, I'm going to focus on the Israeli military law applicable to Palestinian children in the West Bank. And as Lisa mentioned, this, for the purposes of my talk, doesn't include East Jerusalem, because their legal status is a bit different, as is the status of Palestinians in Gaza. Okay. So my choice to focus on childhood stems from the fact that childhood is a key concept for understanding Israel-Palestine in several respects. First of all, international law and Israeli law define a child as a person under 18. So if we adopt this definition, even provisionally and doubtfully, we will find that most people in Palestine are children, and precise figures are about 53% for Palestinians and about a half for Israeli settlers. Beyond their demographic weight, children have been at the forefront of political activity throughout the course of the Israeli-Palestinian conflict. And the child is not only an actual political player in the conflict, but also an icon for this conflict. For example, images of children and stories about children have occupied a central place in representations of the war in Gaza, or the oh, I should have done this on. Right. Do you hear me?
Yeah, it could be better.
Could be better.
Yeah.
I don't know what that is.
Is this better?
Yes.
Wow. Okay. So, to continue with this line of thought, children also embody the collective past and future. Childhood is often used as a platform for thinking about where Palestinian and Israeli societies come from, and about how to secure a desired future for the region. As for Palestinian children under Israeli military law, in the last 11 years, Israel is estimated to have detained around 7,500 Palestinian children in the West Bank, not including East Jerusalem. On average, 321 Palestinian children were held in Israeli detention facilities in any given month between 2008 and 2010. The proportion of children among Palestinian detainees and prisoners ranged from about 3 to 6% between 2001 and 2007. Now, it's very important to bear in mind that law doesn't simply regulate pre-existing children. Instead, law is heavily implicated in the production of the category child. And in the West Bank, two different childhoods have been constructed by two different Israeli legal systems. Palestinians have been subjected to Israeli military law, whereas Israeli settlers have been placed under domestic Israeli law and tried in Israeli civil courts. There are some similarities between these legal systems, but their overall disparity is considerable. And I'll give you some examples relating to children. So the prison sentence rate for Palestinian children under Israeli military law is 94%, as compared with 6.5% for Israeli children under domestic Israeli law.
That's 6.5% just in the West Bank?
No, altogether. For all Israeli children, including Israeli settler children. All of that. The maximum period for detention before being brought before a judge for Palestinian children is 4 days or even 8 days, subject to the discretion of the General Security Services, in contrast to 12 hours for Israeli children under the age of 14, or 24 hours for older Israeli children. Another example, the minimum age for custodial sentences for Palestinian children is 12 years, as compared with 14 years for Israeli children. Now, the focus of my talk will be some changes Israel has recently made to the laws it applies to Palestinian children in the West Bank. Human rights organizations had advocated these changes for years. I will focus on 3 central changes. The first change is the increased separation of Palestinian children from Palestinian adults in Israeli prisons and detention facilities. Until a decade ago, Palestinians were held in Israeli military facilities. And in these facilities, there was very partial separation between children and adults. In military prisons, Palestinian children were held with adults. In military detention facilities, Palestinian children were usually separated, but only up to the age of 16. About a decade ago, responsibility for these facilities gradually transferred from the military to the Israeli prison service. As a result, most Palestinians in Israeli custody are now held in facilities managed by the Israeli Security Service. Because the prison service operates according to domestic Israeli law, all inmates under the age of 18 years are generally separated from their elders. The next development occurred 3 years ago. Previously, Israel used to try Palestinian children and adults in the same military courts, but in 2009, Israel established military youth courts, which were authorized to try Palestinians under 16 separately, at least in some circumstances. And more recently, in September of last year, Israeli military law was amended so that the age of majority for Palestinians was raised from 16 to 18 years. However, the consequences of these legal changes might be insignificant and in some respects even detrimental for Palestinian children. First, the question arises of whether Palestinian children should actually be separated from their elders. In most criminal legal systems, child offenders are held separately from adults. And the rationale behind this separation is that adult criminals are a threat to child prisoners. Now, this assumption can be debated, but in any case, it certainly doesn't apply to Palestinian prisoners in Israeli custody. Most of these prisoners aren't criminal prisoners in the regular sense of the word, but are political prisoners, or as Israel calls them, security prisoners. Another consideration is the Israeli attempts to recruit Palestinians as collaborators. If Palestinian adults would still be detained and imprisoned together with Palestinian children, they could lower the likelihood of these children being recruited as collaborators. In addition, when they were still held together, Palestinian adult prisoners had been reported to give the child prisoners educational services, psychological support, and material care. This is especially important for two reasons. First, the Israeli prison authorities have generally not provided this kind of support to Palestinian children. Second, Palestinian child prisoners rarely see their families because they're usually held in facilities inside Israel. And obtaining permits for family visits in these facilities is a complicated and lengthy process. As for the establishment of military youth courts, contrary to some Israeli statements, military youth court hearings aren't significantly different from hearings involving adult Palestinians. For example, sentencing provisions for Palestinian minors haven't changed since the establishment of the military youth courts. According to a recent report by Israeli NGO Viterbo, the actual sentences these courts impose on Palestinian minors are also the same as in the older system, the previous system. The only significant difference is that military youth court hearings are held separately, at least in some circumstances. In any case, as Lisa mentioned, to a large extent, the real trial doesn't even take place in the military court, but in the interrogation room. The raising of the age of majority has also been inconsequential. On paper, this amendment classified 16 and 17-year-old Palestinians as minors, whereas previously they had been classified as adults. But in practice, this amendment didn't change the court procedures or the incarceration arrangements for this age group. 16 and 17-year-old Palestinians had already been tried in military youth courts since these courts were established, which was 2 years before this amendment. And since 2009, all Palestinian children have been held only in non-military facilities, where they are separated from their adult counterparts up to the age of 18 years. So here's an important question. If the recent legal changes haven't necessarily improved the treatment of Palestinian children, then what functions do these changes serve? Part of the answer to this question may be found in Israeli court judgments from recent years concerning Palestinian children in Israeli custody. These judgments voiced a very clear message that Palestinian children must be separated from adult prisoners and detainees in order not to be exposed to the ideological influences of these adults. Let's look at a couple of examples of this kind of judicial discourse. In 2003, Shaul Gordon, who at the time was the president of the Military Court of Appeals, made two interesting comments in two cases concerning Palestinian children in Israeli custody. So in one case he commented, the appellant is a young youth. If he has not yet adopted the ideology popular among many of the prisoners, then in fact a prolonged imprisonment might lead him to adopt it. And in another case he said, the appellant is held with older prisoners who were convicted of security offenses. The appellant should be distanced from those adults who wished to capture his soul. The exposure to the ideologies of those prisoners and the social pressure may also have their influence. So what we see is that Palestinian children's soul is a site for a spatial and a temporal battle. The battle is spatial between remoteness and proximity. These judgments depict the Israeli side as fighting to distance and isolate the child, whereas the Palestinian child is presented as striving to fix the child near Palestinian adult prisoners. This battle is also temporal. It's a battle against time. The longer children are jointly imprisoned with Palestinian adults, the more likely these children are to be influenced by the adults' ideologies. Palestinian children are perceived as needing to be caught in time, to be corrected, before it's too late, before they're inaugurated into a nationalistic adulthood and can no longer be salvaged. A major factor here is the plasticity
that is attributed to children. This plasticity is a source for the concern that Palestinian children are being indoctrinated. And it's also the source for the hope that these children can be salvaged. The child is seen as easily capable of changing and evolving, but also as susceptible to negative influence and manipulation. These two judgments were given by military courts. I can testify from personal experience that accessing most military court judgments is a very challenging task, to say the least. Most Israeli military court judgments are not publicly available, although they're not secret, not formally at least. And this may explain why there has been almost no research of military court judgments, in addition to the fact that there's also very little research of military legislation. In any case, similar statements to the ones I've just quoted can also be found in judgments of the Israeli Supreme Court. For example, in 2007, Supreme Court Judge Eliakim Rubinstein decided to reject the appeals of two Palestinian children who had been convicted of assaulting an Israeli in the outskirts of Jerusalem. Judge Rubinstein remarked, "Nobody wishes for minors convicted of terrorist offenses to be upgraded in criminality and for prison to become their university for terrorist science." 2 years later, in another ruling, Judge Rubinstein stipulated, "We have repeatedly raised the issue of the absence of social or educational treatment in prison for those convicted of security offenses, when they are minors or very young adults, whose rehabilitation chances are better than those of older security offenders." In conclusion, the recent reform is an attempt to transform the boundaries of Palestinian childhood. These boundaries are physical. They are marked by the sites in which Palestinian children are placed, such as the military youth courts or separate prison and detention facilities for children. The boundaries of Palestinian childhood are also linguistic. They are marked by legal terms such as minor. And these physical and linguistic distinctions are based on age, so that the boundaries of childhood are also temporal ones. As we've seen, the recent reform has been insignificant and in some respect even potentially detrimental in terms of its actual impact on Israel's treatment of Palestinian children. Israeli judgments, such as the ones we've seen, share a common anxiety about intergenerational Palestinian interactions. For some Israeli judges, the separation between Palestinian children and adults is a battle over Palestinian children's future. The idea is that in order to win this battle, the Israeli legal system must do all that it can to create a future Palestinian generation, a generation cured of the nationalism and terrorism of previous Palestinian generations. So to a large extent, the anxiety about the non-separation of Palestinian children actually revolves around Palestinian adults. These are the future adults that Palestinian children might turn into. And these are also the allegedly nationalistic adults that children must be distanced from. So the Israeli desire to govern intergenerational Palestinian relations is a desire to govern not only Palestinian childhood, but also Palestinian adulthood. The recent reform is in fact an attempt to satisfy this desire by redefining who should be placed on each side of the boundaries of childhood. Human rights organizations, which assume and reproduce a certain conception of childhood, had advocated an increased separation of Palestinian children for years. But perhaps constituting Palestinian childhood as an increasingly separate space can be seen as a divide and rule mechanism. Such a mechanism aims to govern both Palestinian children and adults by means of distinction and separation. And in this sense, the aim of the increased separation might have been to expand Israeli state power over the Palestinians. So childhood is a key for understanding the Israeli-Palestinian situation. More specifically, the prism of childhood could greatly advance our understanding of how Israeli military law operates, why it operates in the way that it does, and what symbolic and practical impact it has on the lives of those it so desires to govern.
Thanks. That was very hard to hear. Very good. I want to try and take us a little bit out from the military court and the interrogation rooms and out into what I call the bureaucracy of the occupation, and situate the military court as part of the bureaucratic apparatus that controls the lives of the Palestinians. Because I see the military court as an intrinsic part of the bureaucracy of the occupation, which is not just a set of military institutions in the West Bank. It's a mammoth, complex system that is established both in Israel, within the borders of 48, outside and into the borders of 67. Now, here's just a note. When I'm saying Israeli, I'm referring to the Israeli state apparatus, and when I'm referring to Palestinians, I'm talking about people, persons. And also when I say occupied territories, I'm usually talking about the borders of 67 for analytic purposes. And usually I'll be talking about the West Bank, but that's not really important to me. So since the Oslo Accords, research is focused on the separation between Israelis and Palestinians. And the primary conclusion of this research is that as Israel relinquished its civilian responsibilities of the occupied population, according to international law, it abandoned this paradigm of governmentality that it had. And it now had less control over the daily lives of Palestinians and more control over the borders. So now, according to this scholarship, the population is ruled from a perspective of sovereignty and security that is based on, those goals are mainly related to the annexation of land and the protection of borders. So Lisa called it the law enforcement model versus the war model. I called it governmentality versus sovereignty, but it's essentially the same thing. But in my research of organizations, daily practices, and routines of the bureaucracy of the occupation that's situated within the legal, historical, and military context, I found that through the permit regime that views the Palestinian population through the lens of national security and regulates their movement, the civil military apparatus has more control on daily Palestinian life than ever before. And so, therefore, this idea that there's a movement from governmentality to sovereignty practices, and that this movement means less control over the population, I think that doesn't really describe what's happening. There's more control over Palestinian daily life within the institutions and without. So I want to talk very briefly about the permit regime, the world's largest and most developed organizational mechanism for identifying, controlling, and monitoring the movement of civilian population in a particular area, which I argue is based on a colonial model of bureaucracy that's very different than state bureaucracy as we think of it in Western regimes, which the military court is part of. And then I want to explain the crucial role of the military courts within this system. And if I have time, which I probably won't, I want to talk about the criminalization of political activity in the West Bank through two processes. And the first one is charging political activists in the military court, and the classification of political activists as security threats by the Secret Service. Okay, so permit regime. So my major argument is that the bureaucratic structure that manages the population of the West Bank and the permit regime in particular operates according to a colonial model of rule over subject populations, which is similar to the historical models in the colonies. So, and the principles of this model are very different than what we know of rational legal bureaucracy, namely Max Weber's model of bureaucracy, and basically turns it on its head. The colonial model of bureaucracy is based on racial hierarchy, in which there is one legal administrative structure for the ruling ethnic group and another for the ruled. This principle has been called the rule of colonial difference. We don't usually use it in the Israeli-Palestinian context, usually used in the context of South Asia. I think we can use it in the Israeli-Palestinian context. The permit regime and the closure policy are not a unique model or an anomaly in the history of apparatuses of control over civilian population, as the military courts aren't. British colonies established permanent regimes in Egypt, the Cape of Good Hope, Cyprus, and India, where permanent regimes continued in the independent states, as it did in the military government that controlled the movement of Palestinians within the border of 1948 from 1949 to 1966. Colonial regimes that had difficulty at controlling hostile populations that retaliated against imperial occupation and sovereignty practices based on control of territory, used governmentality-based practices, which were emergency regulations and the surveillance of population. So the history of the permanent regime in the West Bank reflects the colonial foundation on which it was based, and Lisa referred to it. In 1963, there was a plan called the Shaham Plan, which was a backup plan for, in the case that the West Bank would be occupied by Israel, there was a plan to use the emergency defense regulations of 1945, that were a colonial law, in order to create the administrative foundation for the administration of the West Bank and the establishment of the military courts. So the way the system developed was as an administrative apparatus that routinized the legal state of emergency that existed during the time of the British and then was transferred to 1967. And so basically the organizing principles of colonial bureaucracy are racial hierarchy that I just talked about, administrative flexibility, which means there's wide discretion, you're not really sure where decisions are coming from. Personalism, decisions are based on the identity of the applicant or the identity of the person charged. And a constant state of exception, which is basically an institutionalized state of emergency, where you don't really have exact rules. You have decrees, and these decrees change according to the situation. However, usually they change toward the solidification and institutionalization of the measures that are used in emergency. They're usually not brought back. So it's kind of a one-way street. And part of this is also secrecy. Now, secrecy is not just about keeping things secret, it's also about not publishing things. For instance, if I can't access the judgments of the military courts as a lawyer, which I couldn't, but somebody gave me a CD. I once went to ask how I could access the judgments, and some young soldier just gave me a CD with like 1,000 judgments on it, and my life was great, because I had managed to when I come into the back, we can talk about that later. But part of the secrecy is unpublished rules, unpublished directives that are used, and there's no way to appeal them because you don't know that they exist. And I'm going to talk about some of this in just a minute. So the permanent regime is an apparatus to monitor and regulate and control the movement of Palestinian populations from the West Bank into Israel and within the West Bank. Many of you all know about this, but I'll just briefly talk about it. So closure is the prevention of movement within and without the occupied territories. It's basically the spatial manifestation of the permanent regime, and it operates as a tool of sovereignty that creates the foundation for the management of subject populations and the control of movement through documents. The closure is the place where control of population through security forces and violence converges with practices of surveillance and governmentality through the monitoring of the population and the use of military decrees. So in each place where someone's identity documents are demanded, that's another place where these practices are moving. So on the one hand, you control the territory. On the other hand, you control movement. And so the control of the territory is based on physical violence, military power, or the possible use of military power. And the second is the physical control of the territory. Separation wall, barriers, checkpoints, all those. And so there's 16 types of permits in the permit regime that enable more, there's permits to enter Israel for 3 hours, and there's also permits for multiple entry up to 3 months. But the prerequisite to get a permit is to have a magnetic biometric card. And having a magnetic biometric card is what enables a person to apply for a permit. So it's a prerequisite. Now, if you're classified as denied entry, either by the security service or by the police, you can't get this magnetic card, which means you can't get a permit, which means you can't work in Israel. Or, in some cases, you can't travel within the West Bank. I usually talk about entering Israel for labor purposes. I find those cases the most easy to understand. So, as of 2007, there were over 200,000 people that were classified as denied entry for security reasons, and 70 that were classified as denied entry by the police. In June 2007, the police added another 12,000 people as denied entry for security police reasons. So there's security reasons and there's security police reasons. It all goes into one database that's called the Rolling Stone database, and it's actually one database that is used by the police, the Secret Service, the Labor Ministry, the Interior Ministry, and the military. Actually, much bigger, because there is an Israeli Homeland Security. Our Ministry of Interior is also called Homeland Security, similarly, but it's a wider range. It goes much farther in Israel into the political economy and the regulation of the labor market, which is another part which I won't be able to go into today. So you might be asking yourself, okay, what is all this related? How is all this related to the military courts? And the answer is that if you have any kind of charge in military courts that's based on Decree 378, which is the Decree for Security Directives, it's basically the criminal code of the occupation. Any charge, even a preliminary memo by somebody in the police of Samaria and Judea to the military prosecutor on the possible intention of having a charge against you, even if it's a charge about leaving a closed military zone, which is the other side of entering Israel illegally, what that does is automatically turn you into denied entry for security, for police reasons. Because as soon as you have a case in the military court, you're denied entry. And what that means is that you can't get a permit and you can't work. So I have to explain a little bit about the police in Samaria and Judea. It's a police district that was mounted in 1994 following the massacre in Rachel's tomb by Baruch Goldstein. And there is what? Abraham's tomb, sorry. Abraham's tomb in 1994. And so allegedly it was to prevent settler violence against Palestinians, but what happened was that this district became a very important part of the surveillance and monitoring of Palestinian movement, and also they're the source of most of the criminal cases that get to the military court. I have the number here. I think they had in 2004 they had 10 years after they were established. Just in 2004 they had opened 21,144 cases against Palestinians, which all meant that people would be denied entry for security reasons, can't get a magnetic card, can't get a permit. So it's not completely obvious that there should be a police district in the occupied territories, because that's against international law. It's basically considered annexation of land by bureaucratic means. They got around it by having a military commander give personal decrees, nomination decrees, personally to each police officer as an aid to the military forces. So the police were using criteria for the classification of the residents of the West Bank as security threats. And these criteria were used basically from mid-1994, but only in 2007, following a petition by the Association for Civil Rights in Israel, were the criteria revealed. So for most of the time, the criteria that I'm going to describe in a minute were, according to these criteria, people were denied entry, but they didn't know why. So basically nobody knew that it existed. Because what would happen was you would finish your sentence in the military court, and then you would go and try to get a permit so you could work. And you'd wait a year because they told you that for 1 year you probably wouldn't get a permit. But then you went after that year and they told you you were denied for police reasons. But nobody knew why this was. And then in 2007, the miracle happened, and they published the criteria. And I'm going to tell you a little bit about this criteria. So let's just remember what Lisa told us about military court, how it's a factory for plea bargains. And in order to understand this, charge sheets in a military court have 17 or 18 articles, which means that when a defense counsel comes to negotiate with a prosecutor, your starting point is having many charges, and what you do is you negotiate it down. But it was initially like inflated in order to whatever. So you can imagine that most of the plea bargains happen without a trial. There might be an initial hearing, but there's usually no evidence presented. Okay, so basically any association you have with the military court activates these criteria. And so if you've been if the police recommended that you be charged in a military court, then you're denied entry. The case will remain open until a lawyer closes it. Now, it's not a difficult thing to do analytically. I mean, it doesn't take a lot of academic training, but you have to be really persistent and find the person that is going to close the file, and most lawyers just don't have the time or the motivation to do so. So it's very hard to close these cases. Now, the second thing is, since 2004, the wall around Jerusalem was completed, called the Jerusalem Envelope, and then a new border police department of investigation was established to deal with Palestinians trying to cross the wall without a permit. And so they deal with intruder offenses. And the cases they file also reach the military court. I don't have their numbers because I don't know even where they publish them. So if you were convicted on a charge that has a maximum penalty of 7 years, you're going to be denied entry for a year and a half after you receive your sentence. So after you serve your sentence, you get out, and then you have to wait another year and a half until you can apply for a magnetic card and then apply for a permit. If you were convicted on a charge that included violence, you'll be denied entry for 3 years after you serve your sentence. If the alleged crime has a maximum punishment of over 7 years, you'll be denied entry for 4 years. If your trial ended in a non-conviction, or you did not receive a prison sentence, you'll be denied entry for 2 years. If you receive a sentence of 1 year, you'll be denied for 3 years. If you receive a sentence of up to 5 years, you'll be denied entry for another 5 years. And if you receive a sentence of more than 5 years, you'll be denied entry for at least a decade, and there's a complex formula for calculating the amount of time. I did succeed in calculating some, I couldn't calculate others. If you were convicted in a security, what's called a security crime, you may be denied entry for 15 or 20 years. So there's also other kinds of criteria. If there's intelligence that the applicant is involved in criminal activity. And the final one is a general kind of criteria that says there's unlimited discretion. Even if the person doesn't meet any of the criteria above, the police can still deny them entry based on their discretion. And also, if you owe any money to an Israeli citizen, you may be denied entry by the police, or if you have traffic tickets. There were 52,800 something traffic tickets in 2004. I hope I'm not boring. And the reason I I brought this tedious list was because it seemed to me to illustrate some of the experience of the military court, just a tad of it. The police of Samaria and Judea, the panopticon effect of having secret criteria of denial of permit and obstruction of movement based on charges in the military court. What this actually means is while you serve a sentence, usually based on a conviction that is a result of a plea bargain in which there's little or no evidence presented based on an inflated charge that has 17 or 18 charges, and you have to negotiate, as that's been put there to negotiate the leverage for the plea bargain. Once you've been released, you serve a second sentence, which is a denial of access to livelihood for a period of time that's withheld with you. And it's not just a denial of livelihood, because many times when we talk about permits, we're talking about labor permits, which are very important for Palestinian livelihood, the ability to actually remain in Palestine. But the other part of it is also it prevents political organization, it prevents cultural organization. When you can't move, you can't make a state. You can't make a society. It's very hard to do anything basically if you can't move on. This procedural violence comes from this. It produced a tiny organization. This is all produced by a tiny organization inside the police headquarters called the Denied Entry Squad. 4 people work there, 2 officers and 2 clerks. And speaking to one of these clerks, I asked if there was any way to appeal or attenuate the administrative sentence of the classification of one's released from a military prison. She replied that this was an iron criteria. They're computerized and they immediately go into effect in the database of the permit regime called, what we call the Golden Stone. And so basically, the military court and now the prison system itself, which is an Israel-wide prison system, feed this criteria into the database, and it's automatic. So even if somebody wanted to attenuate, there's no legal way to do it. So I want to conclude by expressing a few points about the bureaucracy of the occupation and the practices in the military courts. There's a tendency to speak of the borders of 1948 and the borders of 1967 as different planets. Different legal regimes, separate political structures. One regime a simulated democracy of sorts, the other a military government, one ruled by the international humanitarian law, colonial laws, and military decrees for Palestinians, legal enclaves where Israeli laws apply to Jews in the West Bank, and of course the separation between the military courts and the civil that try Palestinians based on security decrees versus the civil courts that try citizens of Israel and any other kind of population category except Palestinians. However, my work on the bureaucracy of the occupation shows something else. Bureaucratic and disciplinary practices are not quarantined by the imagined geography of British colonial rule. Nothing keeps these organizational practices and routines inside the West Bank or inside the military court. When it comes to Palestinian citizens of Israel, charges, procedures, and outcomes are different than Jews, and in most cases these are different for Mizrahi Jews as well. Palestinians and Mizrahi Jews make up over 95% of the prisoner population in Israel. Why is this important? I think it's important to understand that the military courts are not just of the West Bank. These are not an anomaly. They are not an exception. They're part of a complex labyrinth of bureaucracy of the occupation, which is not an anomaly either. It's not an organizational exception. These organizations and legal sites in which practices of sovereignty and practices of governmentality converge are not an exception but generate a modus operandi that does not stop at any physical level. Thank you.
ככה? מה הוא תופס בצד שם? עוד זווית.
אנחנו מודיעים לכם שהשתנה סדר החיים. קודם כל יש שלטון חדש באזור, והשלטון נמצא בידי צבא הגנה לישראל, ועל פיו יישק דבר.
אם צדקנו, לא צדקנו, זה ההיסטוריונים החליטו.
אנחנו זה אנחנו והם זה הם, אין להם זכויות של אזרחים, לא אזרחי מדינת ישראל וגם לא אזרחי שווייץ או ארצות הברית, אבל הם תושבים ובני אדם, וכך התייחסנו אליהם.
הוא קשר את ידיים מאחורי הגב עם עוד זוג אזיקים, הוא הכר אותי בעיניים באגרופים, נתן לי מכות קראטה בבטן.
מה אתה שואל, אם אני מכיר את הדברים האלה?
אם בתור שופט היית מודע, נגיד
אני הייתי מודע לזה. זה לא דברים שקל לחיות איתם.
אם אתה משוכנע שיום אחד לא תגלה שהרבה מאוד אנשים ישבו...
אני לא משוכנע.
לא תמיד הסדר והצדק הולכים שלובי זרוע.
אתה מנהל משפט כנגד האויב שלך.
לא כנגד, אתה שופט.
אתה שופט, אבל הוא עומד מולך והוא האויב. זו סיטואציה שהיא לא טבעית בשום מצב. אז כל עוד היא זמנית, בסדר. אבל כשהיא נמשכת 40 שנה...
That was an incredibly rich set of presentations. I will try to say a few things while other people think of more intelligent questions. I guess one thing that I'd like to start with is just to restate why this conversation is important to have at this particular time. I think that a lot of the conversations and political debate and international attention concerning the Israel-Palestine situation has in the past few years largely focused on the Gaza Strip, and there have been very good reasons for that, especially with the succession of military onslaughts against the largely confined civilian population there and mass privation through siege and other kinds of economic control policies. So that's quite good, but it does seem as if sometimes in that conversation we have this idea that things are happening in Gaza, there's expansion of colonization processes in the West Bank, but that the instruments of control that continue to be used against the Palestinian population inside the West Bank are more or less those that were established in the wake of the Oslo process, or shall we say the reconfiguration of the occupation during the Oslo Accords. And I think what Hedi and Yael's presentations bring out quite nicely is how not only has the colonization process in the West Bank expanded, but that the instruments of control for the indigenous population there have also grown larger, more sophisticated, more subtle over time in response to quite a few influences. The first, and one that I hope the speakers will have time to elaborate on during our conversation, is the emergence of a sort of native administration that goes by the name of the Palestinian National Authority, whose responsibilities to run kind of day-to-day matters of the population, things that the Israeli forces would prefer not to do themselves, while at the same time Israel manages to maintain and perhaps, as Yael suggested, extend and refine its sort of tentacles in the population. So I think that some of the functions of regulating everyday social control that the Israeli military courts and that the occupation's law enforcement aspect addressed prior to the Oslo Accords may not exist anymore, but in other ways there have been expansions and refinements. And I'm just wondering if there's any way to address kind of the relationship with the Palestinian Authority, the Palestinian police forces, and so on. And of course, it's important just to keep in mind that the Palestinian Authority police forces only exercise jurisdiction, I believe, in less than 18% of the West Bank, basically in the concentrated urban areas that are scattered throughout. So these are non-contiguous areas that are entirely surrounded by areas of direct Israeli military control. And of course, within Area A itself, Israeli forces still maintain overall supremacy to kind of go in and take people out whenever they want. So it's a very limited slice of the pie, but it seems as if it makes sense to factor it into our conversations of how the population there is being governed. The other interesting variable in these influences has been the sort of expanding discourses and institutions of international law, specifically human rights law and laws of war. And Lisa kind of started this part of the story with the emergence emergence of human rights NGOs in the occupied territories in the 1970s and their expansion in the 1980s. And I think Hedi's presentation did a really excellent job of how human rights discourses can actually be appropriated in ways that can actually expand and enhance the state's control over over these populations. Now, what kind of normative implications follow from that is a different issue, and I think it might be something that we might want to sort of collectively engage a bit. But this willingness to speak to international human rights norms for the purposes of furthering the occupation is not at all unique to this particular aspect. So Israeli military lawyers actually have become more and more adept in the language of the laws of war, international humanitarian law, or IHL, over time. They've incorporated some of these laws and discourses in their own policy making. The Israeli courts, the civilian courts, have also selectively incorporated the law of occupation. Israeli military lawyers travel around the world, they give seminars, they engage in reasonable discussions with their colleagues in other countries, and they sort of participate in this transnational sort of debate. And of course, they also have established quite a perch for themselves in American legal academia as well. And there's a sort of growth market in transnational conversations and learning processes in repression and how to justify it. So those are two sort of aspects of these changes that I thought were quite interesting and worth addressing. One sort of larger point, and this reflects my bias as someone who has mostly lived and worked in the Gaza Strip as opposed to the rest of Israel-Palestine, is the question of contextualizing military courts in broader demographic and spatial policies. By which I mean that military courts are not the only way of controlling populations, and that sometimes they even end. So I believe military courts operated with regard to Palestinian citizens inside the Green Line prior to 1966, if I'm not mistaken, which is something that is being researched now, but hasn't been sort of written about as much. And that regime was closed down in 1966, and Palestinian citizens of the state were then incorporated as quote-unquote normal citizens within the quote-unquote normal court process at that time. On the other hand, you have the Gaza Strip, where after the 2005 disengagement with the removal of military bases and colonies from the Gaza Strip, military courts more or less ceased to exist for the Gazan population as well. There are still arrests that take place in the Gaza Strip, but the legal regime that governs them has changed since the disengagement. There's a different set of laws, and I believe they're actually done through the civilian courts now, if I'm not mistaken, through the UN Bath Law query. So it seems to me that that there's this interesting contrast between closing down military courts for a part of the indigenous population that has been incorporated as normal citizens within the state, on the one hand, that's Palestinians inside Israel, and on the other hand, a segment of the indigenous population that has been subjected to essentially a mass form of controlled abandonment. Not total abandonment, because as Yael pointed out, there are still multiple ways in which their lives are influenced or subject to Israel's fiat, but an abandonment of the intimate forms of brutality that people might be familiar with, like house raids and being beaten by soldiers. They've been exchanged for things like being bombed from the air by F-16s and by drones. So I wonder if we could think a little bit about how to place military courts in a spectrum of regimes of control and how they relate to different kinds of political incorporation or exclusion from the broader regime. And also because military court jurisdiction or military orders, at least, still apply to a certain extent within the Green Line, if I'm not mistaken. So, as Yael pointed out, it's important to make sure that we don't kind of exceptionalize this as a West Bank story and understand military courts as one particular instrument that kind of, they sort of like the tides, right? They kind of come in and come out, and the contours of the shoreline change over time depending on the broader kind of demographic and political circumstances. Those are the most important things that sort of came to mind. I'll have other questions. I guess the other thing, and this might come more from the audience than from the presenters, is saying a little bit more about where Palestinians fit into the story. I think we have excellent narratives about how the instruments of control have changed over time, and it would be nice if you had some sort of reflections on to what extent you could address how Palestinian sort of strategies and experiences have been reflected in all of this. And if your answer is, I don't feel like I have authority to talk about it, that's fine, but that's another sort of part of the conversation that I think can kind of extend and continue. I mean, in a way, it's related to this question of the Palestinian Authority and its relationship with both the larger, sprawling, evolving Israeli bureaucracy and also the sort of population in the West Bank and also Gaza that it manages